You fought for your green card, and 2026 feels like the rules shifted overnight because benefits, travel, and paperwork are being scrutinized harder than before. If that makes you angry or scared, pause, because some changes are real, some are lender or agency policy, and some are social media noise. I am Fernando, and you are watching US Policy Brief, where we turn complicated immigration updates into clear steps for green card holders and families. Stay until the end, because the last section explains a quiet risk that can hit even long-time residents who think they did everything right. This video is general information, not personal legal advice. So if you have arrests, long trips abroad, or prior immigration issues, consult counsel before acting. Now let's break down what people call rights being taken away, starting with business financing, then public charge fears, then travel and citizenship pressure today. The goal is protection, not panic, because permanent residence is still strong, but you must understand how agencies and databases interpret your decisions in 2026. First, remember a green card is not citizenship, so some programs and privileges can legally be limited, even when you pay taxes and follow laws. Second, enforcement in 2026 is more data-driven, meaning CBP, USCIS, and even lenders see patterns faster and question inconsistencies more often than ever before. Third, you can respond with planning. Keep records, avoid avoidable violations, and apply for citizenship when ready, not when you are scared by headlines online. Issue 1 is small business financing, because some lenders are tightening SBA loan eligibility and may require full U.S. citizen ownership for certain programs now. When you hear a March 1st deadline online, treat it as a lender policy date, not a universal law, and verify the product in writing. The practical impact can still be severe because a single green card owner in the cap table can cause a bank to decline the application. That hits restaurants, trucking companies, software startups, construction firms, and family shops that hire Americans, pay payroll taxes, and depend on affordable capital to grow. If you plan to seek financing, gather your green card, operating agreement, ownership percentages, tax returns, payroll records, and a business plan before applying anywhere. Ask the lender which SBA program it is using, what citizenship rules apply, and whether lawful permanent residents qualify under the underlying federal guidance today. If one bank says no, shop other sources like credit unions, CDFIs, equipment financing, or secured lines, because standards differ widely in 2026 by lender. Do not transfer ownership on paper just to satisfy a rule, because that can create tax problems, partnership disputes, and new immigration questions later on. Instead, document your legitimate business purpose, keep your bookkeeping clean, and build credit relationships so you are not dependent on one program alone ever again. Financing rules feel like rights, but they are often policy choices, so the winning move is early verification and diversified options for business in 2026. Do not rush into paper transfers of ownership just to qualify, because that can create tax problems, partnership disputes, and future immigration questions. USCIS can review your finances during naturalization, and abrupt ownership changes without business reasons can look suspicious. Instead, build a funding plan that does not depend on one program. Keep your bookkeeping clean, separate business and personal accounts, pay payroll taxes on time, and document your operating agreements. If you are eligible for citizenship and your record is solid, yes, citizenship can expand access to programs. But do not file only because a bank changed a policy. Change number 2 is deeper background screening when you file new applications. Many residents think I-90 renewal is only replacing an expiring card, but in 2026, more cases trigger identity checks and longer processing. Naturalization is even more sensitive. The N-400 process can become a second audit of your immigration history, including how you got your first visa, how you obtained your green card, and whether your answers stayed consistent over time. That does not mean you should avoid citizenship. It means you should prepare like a professional. Gather records, review prior filings, and fix issues before filing. The biggest surprise for many applicants is look back. USCIS can compare your N400 answers to your old I-485, I-130, DS-260, and visa applications. If an old form listed a different address, a different date, or a different marital timeline, you may be asked to explain. This is especially common for marriage-based green cards after divorce, or for cases where an interview was waived. It does not automatically mean fraud. It means you must be consistent and document your story. Pull your tax transcripts, keep copies of filings, and never guess on forms or in interviews. Action steps for this change are simple. Before you file I-90 or N-400, collect certified court dispositions for any arrest, even if the case was dismissed. Confirm you filed taxes every year you were required, and if you owe money, set up a payment plan and keep proof. If your green card was marriage-based, save joint evidence like leases, insurance, photos, and bills, because officers may ask years later. If your history is complicated, a 1-hour legal review can prevent a denial that costs years. Control your narrative early, before filings trigger deeper review of you. Change number 3 is travel tracking. The United States has been expanding biometric entry and exit systems, including facial recognition at airports, and 2026 is a year where records are more complete. That does not mean travel is banned. It means your travel history is no longer a mystery. Border officers can see patterns and compare your answers to the computer. The biggest risk is not one trip. The biggest risk is a lifestyle that looks like you live abroad and visit the United States occasionally. That pattern can trigger abandonment questions and long inspections at re-entry, even with documents. Many people misunderstand the 6-month rule. 6 months is not a magic safety line. It is a guideline. Trips under 6 months are often smoother, but patterns still matter. Trips over 6 months can trigger deeper questions about residence. Trips near 1 year can require a re-entry permit or a returning resident visa. Most importantly, CBP does not look only at one trip. Officers look at your pattern across years, where you live, where you work, where your family is, and whether you spend more time outside than inside. So stop thinking in myths and start thinking in patterns. To reduce travel risk, carry proof that your life is based in the United States. Think like an auditor. Bring a lease or mortgage, pay stubs, an employer letter, a tax transcript, and utility bills. If you expect long travel, apply for a re-entry permit before leaving, because you cannot apply after departure. But the permit is not a license to live abroad. It is evidence of intent. Keep U.S. ties active. Keep an address, keep taxes filed, and keep a job or business connection. At return, answer precisely. If unsure, check records before you speak to officer at entry. At the airport, the most dangerous moment is paperwork. CBP cannot erase your green card instantly, but officers can pressure you to sign a form that gives up status. Do not sign anything you do not understand. Ask what the document is and what happens if you refuse. You may request an attorney and ask for immigration judge review. Stay calm, answer truthfully, and do not guess. Device searches are not routine for every resident, but if you are flagged, your phone can be requested. Travel with clean files and consistent explanations, and keep extra time between flights for delays. Now we need to talk about the story nobody expects: detention based on old records. In 2026, travelers report being held at ports of entry because of convictions from decades ago, including DUIs. A returning green card holder can face admissibility questions, and CBP can check databases quickly. Even if you served a sentence long ago, immigration consequences can still exist. Time does not erase them. The biggest mistake is traveling without understanding your record. If you have any arrest, conviction, or dismissed charge, get certified court dispositions. Carry them when you travel. Do not assume expungement removes immigration consequences. If you have an old case and you are worried, do not let the airport be the first time you learn the consequences. Meet an immigration attorney who understands criminal immigration. Ask whether the offense triggers deportability, inadmissibility, or both. Ask whether you need post-conviction relief, certified dispositions, or a legal opinion letter for travel. Remember, these issues can surface during N400 interviews and even during I-90 renewals. If you are in removal proceedings, do not travel at all. The right plan depends on your statute, your plea, and your timeline, not the nickname of the offense at all. Change number 4 affects refugees moving to permanent residence. Refugees can generally apply for a green card after 1 year in the United States. But in 2026, more cases face rescreening, deeper security checks, and requests for documents before approval. That does not mean every refugee will be detained or denied, but it does mean you must prepare. Keep identity documents, travel history, and copies of statements from your refugee process, because inconsistencies can create delays. File your adjustment on time, attend every appointment, and bring originals. If your history is complicated, get legal help early before problems grow bigger. This refugee point shows a bigger 2026 trend. Agencies are rechecking earlier statements. If you entered through any humanitarian pathway, keep copies of what you filed. USCIS may ask about addresses, travel, family members, and facts from earlier applications. Differences do not always equal fraud, but they can slow your case while officers verify. The fix is organization. Build a folder with applications, receipts, notices, and identity documents. If you do not have copies, consider a FOIA request. And never answer under oath from memory alone. Use records. Consistency is the currency of immigration decisions when scrutiny rises across agencies. Change number 5 is increased scrutiny for conditional residence. If you have a 2-year green card through marriage or investment, you must file the correct petition to remove conditions. In 2026, these cases are reviewed aggressively because fraud prevention is a priority. For marriage cases, USCIS may request more evidence, schedule interviews more often, and sometimes verify addresses. If your marriage is struggling, you have legal options. You can file jointly, or you can seek a waiver based on divorce, abuse, or extreme hardship. The key is timing and accuracy. File on time, track notices, and build evidence early. For an I-751 waiver, you must prove the marriage was genuine and explain why it ended. Evidence matters more than emotion. Collect joint leases, bank statements, insurance, tax returns, children records, travel proof, messages, and affidavits from people who knew you as a couple. If abuse or cruelty occurred, gather police reports, medical records, protective orders, shelter letters, and sworn statements. If divorce is pending, keep proof the case was filed and finalized. Timing is tricky. If you filed jointly and separated, you may need to convert to a waiver so USCIS does not approve the wrong basis. If you file I-751 late, or if USCIS denies your petition, the government can issue a notice to appear and place you in removal proceedings. That does not automatically mean you will be deported, but it does mean your case becomes stressful. Some people can continue the I-751 process in court, but not everyone. The best prevention is early filing, strong evidence, and address tracking so you do not miss biometrics or interview notices. If your spouse disappears, do not freeze. There are waiver options, but they require planning. The sooner you act, the more control you keep. Now the quiet risk, the one nobody talks about, missed notices. USCIS denies cases as abandoned when applicants miss biometrics, RFEs, interviews, or oath ceremonies. Many green card holders move for work, rent changes, or family reasons, forget to file AR-11, and then never receive mail. In 2026, this is deadly because processing is tighter and rescheduling can take months. Protect yourself by updating your address within 10 days, keeping USPS forwarding, and creating a USCIS account. Save every notice as a PDF, set calendar reminders, and check your case status weekly. One missed letter can cost you a year. Another silent issue is taxes. Green card holders are usually treated as U.S. tax residents, and tax filings can become evidence in immigration decisions. If you file as a non-resident, fail to file, or have unpaid balances, USCIS may question good moral character in N-400 cases, and CBP may question residence at reentry. File on time. Keep tax transcripts. If you owe, set a payment plan and keep receipts. If you have foreign accounts, report them when required. Taxes are not only money. They are a paper trail proving you live here. In 2026, databases make inconsistencies to detect. Scams rise when enforcement gets louder. Scammers sell fear and promise guaranteed approvals, travel permissions, or paid shortcuts to citizenship. If anyone asks for cash to protect your green card, be skeptical. Real outcomes are not purchased through messages. Use sources, keep receipts, and work only with attorneys or accredited representatives. Never sign blank forms. Never give away original documents without a receipt. And never believe claims that your green card is canceled automatically by a computer. Status changes happen through legal processes, after notices and opportunities to respond. Your best defense is documentation, caution, and decision-making. Use this checklist this week. Check your card expiration date and file renewals early. Update your address with USCIS using AR11 and save the confirmation. Pull your tax transcripts and confirm filing history. If you have any criminal record, obtain certified dispositions and get a legal review before travel. If you plan long travel, consider a re-entry permit and build a folder of U.S. ties. If you are a conditional resident, start I-751 preparation months early and gather joint evidence. Save notice and set calendar reminders. This checklist is boring, but boring keeps you safe in 2026. Seek legal help when facts are risky. If you have any arrest, conviction, fraud concern, old removal order, or long absence, get individualized advice before traveling or filing. If your marriage is ending and you must file I-751, do not guess. If your case is delayed far beyond normal times, ask about options like service requests, congressional help, or in rare cases, a lawsuit. If you are about to file N-400 and you feel nervous about past issues, review your record first. A short consultation is cheaper than a denial and years of waiting. Use professionals, not rumors. Immigration anxiety is real. Many residents spent years waiting, interviewing, and proving themselves, so loud enforcement headlines can reactivate old fear. You may feel targeted even if you followed every rule. That feeling is human, but do not let it drive decisions. Replace doom scrolling with routines. Organize documents, set reminders, and check sources weekly. Talk with family about travel plans and deadlines. If stress becomes overwhelming, community support or counseling can help because mental health matters. You earned your residence through a hard process. You deserve stability, not panic. Knowledge is protection, and habits are your shield in 2026. Should you apply for citizenship in 2026? If you are eligible and your record is clean, citizenship is the strongest protection because citizens cannot be deported and cannot be denied entry. Processing times vary, but cases move. Still, do not file only because you are scared. File because you are ready. Read the N-400 carefully, especially travel, taxes, and arrests. Review how you got your green card, especially marriage cases, and gather proof. If taxes need correction, fix them first. If court records are missing, obtain them first. Then apply with confidence. Citizenship should feel like a finish line. Recap of the top 5 2026 shifts. 1. Financing rules tighten through lenders, so verify SBA-style requirements in writing and keep alternatives. 2. I-90 and N-400 trigger deeper background checks and look back, so prepare records before filing. 3. Travel is more data-driven, so plan trips, carry U.S. ties, and avoid abandonment patterns. 4. Refugee and humanitarian adjustments can face more rescreening, so keep copies and stay consistent. 5. Conditional residents face strict I-751 review, so file on time and build evidence early. Across all 5, the winners are people who respond fast and never guess. You do not need panic in 2026. You need a system. Keep a folder, paper and digital, with your green card, passport, tax transcripts, court dispositions, and USCIS receipts. Keep a simple travel log. Update your address quickly and save AR-11 confirmation. Resolve tickets and court dates fast. If you are eligible for citizenship, prepare N-400 with documentation and confidence. If this helped, subscribe to US Policy Brief for calm weekly updates. Like the video so more residents find it. Comment your biggest question and I will cover it in the next episode with sources and practical steps. Final reminder, lawful permanent residence remains a powerful status, and most green card holders live normal lives without trouble. What changed in 2026 is visibility. Small mistakes show up faster, and unprepared people lose time. Take one idea from this video. Preparation beats fear. Verify lending rules, track travel, clean up records, file on time, and keep copies. If you receive an official notice, do not ignore it. Read it, calendar the deadline, and respond with evidence. You worked too hard to build your life here. Protect it with calm routines, and you can move through 2026 stronger than before.